Specifically, the ones I think that are really important for them to know is that they have the right to have their safety taken into consideration when a magistrate or a judge is setting the bail amount for a defendant. They have the right to be informed about court proceedings, the court process. They have a right to be informed about any plea bargain offers that the state may offer the defendant, and things of that nature. And so, in addition to crime victim compensation, if they have medical bills or relocation bills, and those are all things that, even though they're not the ones that are the party to the legal action, they still have a right, and that's in the Code of Criminal Procedure that they can take advantage of. But the prosecutors and the state agencies that are the ones bringing these cases, the victims are still the most important people to them. Even though they may not be the ones, that person versus the defendant, the prosecutors want to hear from victims, and the prosecutors want the victims to be involved and cooperating with them, because at the end of the day, the prosecutors are trying to make the community safer for everyone, and specifically the victim safer. So if we don't know what the victim's situation is, and if we haven't heard from the victim, we don't know how to help her or him. We don't know what their needs are. We don't know. And so I would encourage even victims that they can call and talk to the prosecutor and explain their situation and say, I still don't want him to be prosecuted. That's fine. At the end of the day, the onus is not on the victim to do anything. And oftentimes in these domestic violence situations, that's a difficult situation for a victim to be in. And so we don't want to put the burden on them of making this huge choice of what should happen to the defendant for crimes that they may have committed against the victim. They may have children together. They may have shared finances together. It can be very complicated.
But it also includes medicating, over-medicating an elder to keep them quiet, or to keep them controlled, or to keep them unaware of what's going on. There's also cases of sexual abuse. We don't see that very often. It's a very, very small percentage of what we investigate, but it does happen. And then there's also, and perhaps most significant for us, is neglect.
The state prosecutor is going to be the one that makes the decisions ultimately about whether or not they will go forward in a case. And sometimes that means a prosecutor could even go forward in a trial and get a conviction without the victim ever coming to court or without the victim testifying. I think that's important for them to know, because despite that the prosecutors do want to protect the victims, we have to protect the entire community as well. And so sometimes the prosecutor is the best person to be in that situation to make that decision instead of the victim, who could have retaliation or repercussions for cooperating. A lot of times victims will get contacted by investigators or other defense attorneys or things of that nature, asking for them to participate in an investigation. And it's important to note that legally victims are not required to speak to these people. If you don't want to speak to an investigator, you don't want to speak to a defense attorney or even a prosecuting attorney, victims do not have to do that. The only thing they have to do is if they receive a subpoena, they have to appear in court. That's all you have to do. Failing to appear when you have a subpoena, it's not an invitation, it's a court order. And so the consequences for not coming to court when you've been subpoenaed can be put in jail, or you can face up to a $500 fine, or both. So it is important for victims to understand that.